the reason for financial contributions made by another section of the population, a student, a daily wage worker, an artist, or a teacher. When the law permits political contributions, and such contributions could be made as an expression of political support, which would indicate the political affiliation of a person, it is the duty of the Constitution to protect them. Not all political contributions are made with the intent of attempting to alter public policy. Contributions are also made to political parties which are not substantially represented. Contributions to such political parties are made purely with the intent of expressing support. It is true that contributions made as quid pro quo transactions are not an expression of political support. However, to not grant the umbrella of privacy to political contributions only because a portion of the contributions is made for other reasons would be impermissible. The Constitution does not turn a blind eye merely because of the possibilities of misuse. Thus, the right of informational privacy extends to financial contributions to political parties, which is a facet of political affiliation. We have applied the double proportionality standard to balance the conflicting rights of the right to information and the right to informational privacy. The Constitution does not establish a hierarchy between the right to information guaranteed under Article 19(1)(a) and the right to informational privacy to political affiliation traceable to Articles 19(1)(a), 19(1)(b), 19(1)(c), and Article 21. The Union of India submitted that Clause 7(4) of the Electoral Bond Scheme balances the right to information of the voter and the right to informational privacy. We are of the opinion that Clause 7(4) of the Electoral Bond Scheme does not adequately balance the rights, but rather tilts the balance in favor of the right to informational privacy because A, the suitability prong of the proportionality standard is only partly fulfilled. The non-disclosure of information grants anonymity to the contributor, thereby protecting informational privacy. However, there is no nexus between the balancing measure adopted with the purpose of disclosure of information to the voter. According to Clause 7(4) of the Electoral Bond Scheme and the amendments, the information about contributions made through the Electoral Bond Scheme is exempted from the disclosure requirements. This information is never disclosed to the voter. The purpose of securing information about political funding cannot be fulfilled by absolute non-disclosure. B, we have proceeded to apply the subsequent prongs of the double proportionality standard, assuming that the suitability prong is satisfied. Section 29(c) of the Representation of People Act, which states that information of contributions made below rupees 20,000 in a financial year need not be disclosed, is a lesser restrictive means to achieve both the right to information and the right to informational privacy. The underlying rationale of Section 29(c)(1) is that contributions below the threshold do not have the ability to influence decisions, and the right to information of financial contributions does not extend to contributions which do not have the ability to influence decisions. Similarly, the right to privacy of political affiliation does not extend to contributions which may be made to influence policies. It only extends to contributions made as a genuine form of political support. It is quite possible that contributions beyond the threshold of rupees 20,000 could also be a form of political support and not necessarily a quid pro quo arrangement, and contributions below the threshold could influence electoral outcomes. However, the restriction on the right to information and informational privacy of such contributions is minimal when compared to the provision of blanket non-disclosure. Thus, this lesser restrictive alternative realizes the right to information of an informed voter and informational privacy to political affiliation in a real and substantial manner. The Union of India has been unable to establish that the measure employed in Clause 7(4) of the Electoral Bond Scheme is the least restrictive means to balance the rights of informational privacy to political contributions and the right to information of political contributions. Thus, the amendment to Section 13(a)(b) of the Income Tax Act, introduced by the Finance Act 2017, and the amendment to Section 29(c)(1) of the Representation of People's Act are declared unconstitutional. The question is whether this court should only strike down the non-disclosure provision in the Electoral Bond Scheme, that is Clause 7(4). The anonymity of the contributor is intrinsic to the Electoral Bond Scheme. The Electoral Bond Scheme is not distinguishable from other modes of contributions through banking channels such as checks, transfer through the electronic clearing system, or direct debit if the anonymity component of the stream is struck down. Thus, the Electoral Bond Scheme 2018 will have to be struck down as unconstitutional. Issue 4. Whether the amendment to Section 182(3) of the Companies Act is unconstitutional.